Professor Lindsay Robertson, and I'd like to welcome you to this class in criminal jurisdiction in Indian country, or law and order in Indian country, one might call it. It's a course in our Masters of Legal Studies program in Indigenous Peoples Law, and it's an important course. Criminal law, the exercise of the power of a government to prosecute, is an important component of sovereignty for any government, in particular for tribal governments. What's one of the things that tribes do in the United States that sets them apart from indigenous peoples elsewhere in the world. And for this reason, it's important to exercise the power to assert tribal sovereignty, such as the position of most, if not all, tribal governments. It's also important to understand exactly how that assertion works, what the rules are governing the exercise of criminal jurisdiction, what the limitations are on the exercise of criminal jurisdiction. This helps us understand better exactly how tribal governments function in general, but it also, as we'll learn before the end of the semester, opens up possibilities for advocacy for those viewing this lecture interested in areas in which they might work to enhance tribal sovereign power. This is one of the areas in which advocates for expanded tribal sovereignty have had great success in recent memory. And it's an area in which advocates of other positions have found it important to involve themselves. Trial lawyers operating outside of Indian country, for instance, were very involved in the reauthorization of the Violence Against Women Act provisions relating to expanded criminal jurisdiction for tribal courts. This is all introductory, though. These are all topics that we're going to talk about in some detail over the course of the following lectures. For now, for present purposes, I want to introduce the topic of criminal law, of criminal jurisdiction, so that we understand exactly what it is that we're talking about. And to do that, I'd like to introduce something that we're not going to talk about in this series of lectures, and that's civil jurisdiction. Now, in the broadest sense, in the world in which we live, most nations divide the power that they exercise in half, conceptually. There's criminal jurisdiction, which we're going to be talking about, and then there's civil jurisdiction. And civil jurisdiction has two components. First is civil regulatory jurisdiction, and the second is civil adjudicatory jurisdiction. Now, the civil areas, these are things that we'll talk about in other lectures, but they're important too. And it's important to understand exactly what each half of these means, civil regulatory, civil adjudicatory, because we're going to run into them again and again during the course of these lectures. Civil regulatory jurisdiction is the power of governments to make folks do stuff. So it's the power that allows the state to say, you've got to attend school up to a certain age, or you have to be a certain age to get married, or you need a license to use the highways of the state, or you have to pay income tax, or you have to pay business tax, or you need permission from the county before you can build the house that you're planning on building in the area in which you want to build it. These are all activities regulated by the government. They're activities in which folks can engage, but they've got to do it according to the rules that the government sets forth. Civil regulatory jurisdiction is the most commonly exercised form of jurisdiction by governments. When we think about what governments do, we usually are thinking about civil regulation, regulating the conduct, setting forth the rules under which we all interact with each other and with society as we go about our daily lives. Civil adjudicatory jurisdiction is the vehicle through which the state helps us as individuals resolve our disputes. If we get into an argument over who owes who money, or whether the construction project that I asked you to do you actually did according to the terms of the contract, or if I run into you and you're unhappy and you think I should pay you some compensation as a result, then we go to court. Or in other cultures, we subject ourselves to whatever dispute resolution institutional mechanism the government has created to exercise its civil adjudicatory jurisdiction. Adjudicatory just means dispute resolving. And we're used to thinking of this in terms of courts. That's how the states work. That's how the federal government works. It turns out that's how most tribes work too, although as we'll discover in a different course, which will focus on civil jurisdiction, we'll see that tribes sometimes resolve disputes in ways that seem unfamiliar, employing traditional methods of dispute resolution. It's worth mentioning at this point that even Western cultures haven't always resolved disputes via an adversarial court proceeding where both parties are usually represented by lawyers, and there's a judge with a black robe in the back who takes evidence, allows witnesses to testify, upholds objections, impanels and empowers a jury, invites a jury to resolve factual issues, etc. The English system, for instance, years ago, was much simpler. We're going back to the 15th century here. But the English, in lots of instances, thought that there was a more helpful, active role that might be played by divine power in the resolution of disputes. And so they commonly had civil disputes resolved through what was called a trial by combat or a trial by battle, and that's where a couple guys would basically go at each other, either with clubs or on horseback, with lances, and whichever one, it was assumed, did so because God had favored his position in the civil litigation, and so we're done, and that's fairly easy. So the fact that England had a different method, a radically different method of adjudicating disputes within the last 600 years, that's a method that's evolved over time, of course, to where we are now, but ought to impress upon us the notion that the fact that different societies have different ways of resolving disputes is just evidence of how different people can be. There isn't one method of dispute resolution that's better than any other. They're maybe better at accomplishing certain objectives. The trial by battle was certainly efficient, but they're all part of the rich tapestry, or many of these variations we're going to discover are part of the rich tapestry of dispute resolution in Indian country. But again, that's a topic mainly for another time. So civil regulatory jurisdiction, civil adjudicatory jurisdiction, and then there's criminal jurisdiction. Now, criminal law is the collection of values of a community coupled with some indication of how seriously the community takes those values. What I mean is, it's not, criminal law is not sort of, well, it's okay for you all to do this, but we just want to make sure that you're not bumping into each other and that your activities are sort of are regulated in some way by the central government. Criminal law says you shall not do this. By implication, it's the sense of the community. This is not acceptable behavior, whatever it happens to be. And of course, that can vary from culture to culture as well. Now, the seriousness with which the community takes infractions of those articulated moral values is the punishment part of criminal law. So we are so serious about this that if you violate this injunction, this mandate that you not engage in this sort of behavior, we're going to put you to death. That's pretty serious consequence, and it's evidence of how seriously the community takes that particular moral norm. Some things, less so. You shouldn't steal gum from a 7-Eleven. Okay, and if you do, then we're gonna, I don't know, maybe a week of community service. So it's still prohibited activity, but the moral infraction is less troublesome to the community as a whole. And every community comes up with these. They either inherit them from their ancestors and just accept these as the moral views of our community, these are the punishments, or they modify them because of changed circumstances. One instance of that, again, from sort of the Old English model, the British government, or the English government, on the eve of the Revolution, penalized practically every criminal law violation with death. And you know this if you read old novels. You stole a loaf of bread, death. You murdered the widow, death. You beat up the orphan lad, death. There really wasn't a whole lot of play in the sanction section. The consequence, of course, was that juries found ways to let people off if they didn't feel as morally outraged as all that. But when the colonies in what became the United States revolted, one of the first things several of them did, including most famously Virginia, was to propose new penalties for offenses. So theft, maybe not death, maybe, you know, some time in prison. How does that sound? And maybe the amount of time that you spent in prison would vary according to the offense. So there's a movement towards proportionality in the sentencing of a lot of these, for the commission of a lot of these offenses. There had been some variation in the colonies before this, and I suppose in England as well. And I'll say a word about that because it'll be an entree to punishment structures for indigenous communities in North America as well. Way back when, and this is pre-colonial, so we're going back into England, the Anglo-Saxons had a doctrine of penalty by payment of something called the weergeld. And the weergeld was where the Anglo-Saxon word for man and geld, which is the origin of gold for cash compensation, was your value in the event you were killed. So if you killed me, then your sanction would be paying compensation, whatever my price is, my weergeld, to my family. The goal being community preservation, because we're small bands, we can't afford to lose people by putting them in prison, by executing them, etc. The goal is restoration of relations. I mention that because when we get to tribal sanctioning, we'll see that this in the 19th century was very similar to what a lot of the tribes did. In the interest of community preservation, to require compensation in the event of even of murder, as opposed to incarceration or execution. In the colonies, moving forward, we have a period where incarceration's an option, execution's an option, but we also see shaming as punishment. And if you ever go to colonial Williamsburg or places like that and you see the stocks where people were placed with their heads out and their hands in, the goal there was humiliation, community shaming. Children would throw fruit at you, this sort of thing, but the goal was that you would finish your time in the stock sufficiently embarrassed that you would never do this again, whatever this happened to be. You'd be restored to the community. And shaming, we're also going to see in certain indigenous communities, even to this day, variations on that. Now, the modern prisons, as we think about, when we think about punishment for the commission of crimes, we tend to think of prisons are really a 19th century phenomenon. In the early 19th century in the United States, a movement started to sort of study criminal behavior and try and figure out why it was people were committing these offenses and what we could do to stop them from doing it again. We've stopped executing people for every offense. We've got to do something else with them. And the theory developed in the northern states that maybe what was going on was people were committing crimes because they were running with bad crowds. So maybe what we need to do to stop them from committing crimes is to take them away from those bad people, take them away from whatever the influences are, put them in a sort of state-sanctioned and run timeout program where they'll sit in a little place and we'll give them commonly the Bible to read, and we'll either keep them separated from all other human beings for the duration of their stay, or, and that was called the separate system, or if we allow them to see other human beings, they won't be able to talk to each other. And that was called the congregate system, and the former was developed in Pennsylvania, and the latter in New York. But in either of these cases, the idea was that they would use their time in this isolation to become penitent, to become aware of the harm that they had caused, to reform their character so that when they emerged, they would be contributing members of society. And for this reason, these facilities were called penitentiaries or reformatories. And this was the idea. This took off, by the way, and became one of America's great exports to the world, the prison system. A guy named Alexis de Tocqueville came over from France with a friend to study it and ended up writing Democracy in America, in addition to his report on prisons in the 1840s. And other countries in the world adopted this penitentiary/reformatory model. So what I care that you take from this isn't so much that that's what we need to do, but that's just one method for punishing people for committing violations of community moral norms, otherwise known as crimes. And it's a fairly recent method for dealing with those sorts of problems. And this is important because when we get to the tribal exercise of criminal jurisdiction, we're going to look at tribal variations, at different ways to penalize people that maybe won't look like that early to mid-19th century penitentiary model that the United States chose to adopt. And we should feel okay about that. The one is historically contingent, the penitentiary model, on a given time, place, and culture. And so the fact that other communities do different things shouldn't upset us, I guess, is my principal point. Now, the last thing I want to mention now, and then we'll take a break, has to do with who we're talking about here as the players in the exercise of criminal jurisdiction in Indian country. And it turns out that there are three. And they're the three sovereigns who occupy the lands that form the United States. First, of course, is the tribe itself. And we're going to spend a fair amount of time talking about just what it is that tribes do, what tribal criminal jurisdiction is, how it's exercised, what the limitations are imposed by the federal government, and how violations are penalized. But we're going to set that aside and do that towards the end of the semester. The second of these sovereigns are the state governments. Now, the state governments predate the Constitution in a sense, although in their present incarnation, they're arguably creatures of the Constitution. But the state governments exercise what we call a general police power, which means they can do anything they want that governments do, except to the extent that they're limited in their range of action either by their own Constitution or by the federal Constitution in some way, either directly or because Congress has passed a statute saying, no, you can't do that. And the state governments from an early day began expressing interest in exercising their own criminal jurisdiction in Indian country. We're going to talk about the states. We're going to talk about the early case, 1832, Worcester versus Georgia, in which the Supreme Court had to decide whether a state, specifically the state of Georgia, had the power to enforce its own criminal law in Indian country, specifically the Indian country of the Cherokee Nation. And then we're going to see what's happened in the years since then, as states have continued to try to claim the power, in certain instances successfully, to exercise their own criminal jurisdiction, to enforce their own moral standards and beliefs, and to enforce their own penalties on people who engage in activities in Indian country. And the last of these sovereigns is the United States of America, the federal government. The federal government is not a government that exercises general police power. The federal government only gets to do what the Constitution says it can do. It's a government that exercises what we call delegated powers, and for the most part, they appear in one section, one part of the Constitution. Article 1, which deals with the powers of Congress and how Congress is constituted, etc. Section 8, which is a list of the stuff that Congress gets to do. Now, most of those things that Congress gets to do have nothing to do with criminal law. In fact, there are only a couple provisions that expressly grant Congress the power to pass criminal laws. Congress is empowered to provide for the punishment of counterfeiting the securities and current coin of the United States, so Congress can pass laws criminalizing counterfeiting, and Congress is empowered to define and punish piracies and felonies committed on the high seas and offenses against the law of nations. So violations of international law, Congress can punish, and piracy and other bad things that happen out on the open water. And that's it as far as express grants of power to Congress to pass criminal laws. But as you all know, Congress has passed loads of criminal laws that have nothing to do with piracy, crimes on the high seas, international law, or counterfeiting. It's done so based on its implied power to pass criminal laws. I'll give you one instance of that. Congress is empowered to establish post offices. Well, what happens if you steal the mail? Well, it's a crime. Well, why is it a crime? Congress isn't empowered to criminalize mail theft. Yes, but Congress is empowered, and this is the last sentence of Article 1, Section 8, to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. So, the argument reads, if we can establish post offices, then it's necessary, if that's going to work, that we also punish the theft of mail or the killing of postal workers or whatever we happen to think relates sufficiently to the power to establish post offices. In the Indian context, Congress's thought was we can, as we'll see, legislate criminal laws or apply federal criminal laws in Indian country or to tribes pursuant to a different power, which was Congress's power to regulate commerce with the Indian tribes. And it's that commerce power, that Indian commerce power, coupled with necessary and proper, that's going to inspire our first great federal intrusion into the criminal jurisdiction sphere in Indian country that we're going to talk about in our next lecture.